Hello, everyone, and welcome to HR Options webinar series. My name is Amy Julian, and I'm the Vice President with HR Options, and it is my pleasure to be your moderator for today's session when we're going to dive into the 2016 legal updates in the specific areas of compensation and discrimination. I am so pleased to have one of our regular speakers, employment attorney Jeanine DeBacker, here with us today to share what's new for California employers that we all need to be aware of. I thought we had enough on our plates, but apparently I was wrong. So before I pass the mic over to Jeanine, I want to review the features of our online meeting room so you can better interact with us. You'll notice several windows open on your console, including the Q&A window, that you're welcome to submit questions throughout the session by typing a question in the box and hitting submit. We'll respond to all the questions at the end of the session. For those of you who are looking for the certificate for continuing education credits, or if you'd like to print out the slide deck to take notes on that, please go to the resources window on the middle right side of your screen. And lastly, there's an evaluation widget at the bottom of your screen. It's red. And I'm going to ask you to complete the evaluation at the end of the session. If you have to leave early, please just take a moment. It's 7 questions, really quick. We offer these webinars to our clients and contacts, and we really want your feedback on how we're doing with the trainings and what you'd like to see in the future. HR Options offers the webinar series because we truly believe in the value-added services. We offer outsourced HR support services as well as outsourced employment throughout the U.S. and Canada. So contact me if you need part-time HR support or if you want to outsource the employment of some of your workers. And with that said, it is my pleasure to introduce Ms. Jeanine DeBacker. She is a partner with McPharlin, Spinkles & Thomas, LLP, here in the Silicon Valley. Her expertise is in employment law, and Jeanine has worked with HR Options for many years now on employee relations issues as well as compliance issues, and honestly, she's one of my favorite attorneys. So thank you so much for being here with us, Jeanine, and I'll let you take it away.
All right, great. Well, good morning, everyone, and thank you for participating in this webinar. Like Amy said, I do employment defense, and back 15 years ago, maybe 5 years ago, I did these types of webinars to market and to try and get more work so I could do more defense of litigation. And I have to tell you, the focus of my webinars over the past couple of years has been to try and help you and you working with an HR Options HR consultant firm to try and avoid litigation no matter what, because I got other stuff to do. And so the whole goal here is to try and reduce litigation. While litigation makes it really great for my kids' college funds, it's too expensive for employers, and we really want to reduce it. And so that's the goal here with these types of webinars, and working with your consultant and working with increasing your knowledge is critical. That was a very clumsy intro, but I was just thinking about, I was just jotting some notes for the practice I'm going to run late this afternoon for my Little League team, and I have to answer some discovery responses first. And I was like, well, that's really getting in the way of my important managerial duties. So I'm going to focus on 2 issues today, compensation and discrimination. And there's obviously more issues and new things for 2016 that came about mostly July 1. A few of you know about paid sick leave. Just kidding, because you all know about it. And then there were some changes to the California Family Rights Act. But today I'm going to focus instead on compensation and discrimination, because this is what I'm dealing with for the most part every day, and it has not abated. And I wanted to walk through the changes to the law and how that affects you. Even if you look at the face of the slide, you might say, this doesn't really affect me. As I talk about it, I'm going to point out why I think it's so important and why it's a great prompt for you as an HR professional or a finance professional to be thinking about the things I'm going to raise. So don't be discouraged by what the title of the slide says, because I left it in for a reason, even though you might say, these don't apply to my workers. But it does, so hold on. So, well, there's my signal to say the first thing I'm going to talk about is compensation. and that's wage an hour, how we pay employees, how we've classified employees. And so the first thing is just a reminder that as of the first of the year, California minimum wage went to $10. And I think everybody's ready for that. I had a couple, sometimes I have smaller business owners who are focused on actually, just the day-to-day running to their business, and then they listen to the radio or watch TV and they hear about proposals for a minimum wage to be $15 an hour. And so they were calling me and saying, what are we going to do? And I said, well, that's not the case yet. It's $10 an hour. Overtime is $15 an hour, right, because that's time and a half. And in California, we pay overtime for any time over 8 hours in the day. We ignore, for the most part, what other people in other states do. So it's an 8-hour day minimum, plus if you exceed 40 hours in the work week, then overtime is due for that as well. But I put this in because the next line, the properly classified exempt employee. And so this is a prompt to say, are your employees that you're paying a salary and not paying overtime, are they properly classified? And the more times you can double check that, the better, because that's one of the things that has really contributed to my children's college fund is misclassification of employees. And so you want to take a look at who are you paying a salary and why, what is the basis for paying them that salary? Did somebody go through the classification and determine that this person is doing exempt work? And it's not something to just put your head in the sand and say that's the way it's always been done. And I know sometimes you as HR professionals bump up against other people who don't do HR, who don't want to do the analysis. And so you have to do the hard lifting of explaining to them why it's so important and why the penalties and the overtime, et cetera, can just be crippling if it's not resolved as soon as possible. So if you have exempt employees, you have to make sure that they're properly classified, that their salary was bumped up appropriately as of the first of the year, because there's the duties test for exempt employees, which means what are they actually doing, and then there's the salary test, how much are they being paid. And some employers pay their exempt employees right at that number, which is 2 times minimum wage, and so now that is $41,600. And if your company is paying exempt employees the minimum for exempt employment, which is $41,600. It used to be based on a $9 an hour, so now we've had to increase it. So you need to make sure that that wage amount has increased. Normally I talk this whole properly classified, we could talk about for hours, get a big cup of coffee, because it's just such a big deal. And so I just wanted to kind of throw a couple words out there. If you have customer service reps, if you have account managers, if you have supervisors who aren't supervising anyone, it's really important to work with, or to take a look yourself and to work with your consultants and professionals to determine are they properly classified, so that if they're not, you can come up with a plan of attack to resolve it. And you want to resolve it. You don't necessarily need to do an all-hands meeting and tell all of your employees that you've been mispaying them for years, but we come up with strategies to correct and resolve those actions. And so in addition to paying them on an hourly basis, you want your non-exempt employees to be having the opportunity to receive meal and rest breaks. So this properly classified exempt employees is really just an excuse for you to circle that phrase and say, I need to take a look at my exempt employees. Are they really being classified correctly? If you are paying computer software professionals, then in October of 2015, as usual, the Labor Commissioner issues this a statement, a PDF basically on the Labor Commissioner's website that says, oh, we're increasing the minimum wage for computer software professionals under the exemption. So there's a multitude of exemptions. There's the administrative exemption, and that's usually for your back office personnel. So if they're doing back office personnel operations and they're paid at least 2 times minimum wage, then generally they would be exempt. And then you have the executive exemption, which is for people who manage 2 or more people on a real management type basis, and they also need to make 2 times minimum wage. And then there's the computer software professionals, and they are actually drafting software. They're creating software. They're not your IT manager. They are computer software professionals, and their salary minimum is either $41.85 an hour as of the first of the year, or about $88,000 a year. And that increases almost every year. There was a correction a few years ago that brought it down a few thousand, and now it's just steadily going up. And it's based, my favorite part is how they, when you read the materials, they talk about, oh, we did a cost of living analysis and a market analysis, and so your computer software, the cost of living, you know, $41, but then and then you go to the other documents where it talks about the minimum wage of $10. So it's pretty interesting. As a reminder, for the computer software professional exemption, which is in some ways a little bit different from your executive and your administrative exemption, it's just an exemption from overtime. So if you have people and you're paying them under the computer software exemption, you want to make sure that you have given them a document or have something on your intranet that says, we encourage you and you are given the opportunity to take your meal and rest breaks. That magic language that we all want to use now after, let's say Kenneth Cole, but it's not Kenneth Cole. It's the, oh my gosh. Well, you know, sorry. This is your chance to sit there and say the words to me like, I did the other day. I was in line at Trader Joe's, and they were talking about a baseball player. And the two guys, these big tough guys, couldn't remember the guy's name. And I was behind them, and I was like, Zach Greinke. It's Zach Greinke. So now you can say that. And I can't remember the name of the case. The big case about meal and rest breaks that I look at constantly.
Brinker?
Okay. Yes, Brinker. The Brinker case. See, there we go. The Brinker case. So I actually had an attorney lecture me a couple months ago, and he goes, I don't know if you've read the Brinker case. And I'm like, really? Tell me about it, because you're still wrong. My client was right. So in the Brinker case, you want to have that language. And if you don't have that language, and if my mentioning of the Brinker case or the words like having the opportunity to take a meal or rest break, if that causes a perk in your ears, then circle this and make sure that you go and check out your policy statements about allowing people the opportunity to take their meal and rest breaks. And if you're new to your company and you are stepping into a situation where they had a long-time awesome HR professional, there is no shame in going and double-checking that that got changed because, as you know, you're swamped. And sometimes best intentions don't work out. And so you want to circle that as something to do to make sure you got that language and that it's been distributed and that you don't have any situations that I call the rogue manager, where I have great policy language about taking meal and rest breaks. Or I've done a great analysis of the exemptions, and then I have a rogue manager who, unbeknownst to the HR department, is thwarting all that by telling people, no, you can't take a break, or if you really want to get your work done on time, you better skip your meal break and stuff like that. So check that all out. Okay, so that's the new effective January 1, 2016 wage rates. And then I'm going to go into this issue of piece rate. And I know that the number of people who actually pay their employees on a piece rate on this call is probably in the low percentages, probably single digits. But the importance of this case is not necessarily the fact that it's about piece rate, but it's about all the other things that it touches and raises issues with. So don't zone out any more than you would normally zone out for a webinar. So a new Labor Code section 226.2 was put in place as of January 1 regarding piece rate compensation. And if you sat through HR Options update last year, which I listened to, and it was awesome. And then the year before that, there's discussions of these cases. And the main one was called Gonzalez versus Downtown LA Motors. And there was another one involving Safeway. And it talked about when you're paying people on a piece rate or activity-based formula. And so in Downtown Motors, the issue was mechanics were being paid on a piece. So if you fixed a transmission, you would get X amount of money. And then when there was no car in that person's bay, well then theoretically they weren't being paid because there was no car there. So that was, but they were still expected to be there, still expected to keep the bay clean, take out the old motor oil, etc. And so there was a case that talked about, oh no, people need to be paid at least minimum wage when they're sitting around, right? Because if you're not at home eating Doritos and watching TV, you're at the office or you're at the mechanics bay, you need to be paid. If you're not doing what it's not free time, then it's paid time. And so that law came out, and then there's been issues about, okay, what about meal and rest breaks when people were on piece rate? So there's a lot of confusion in that area. So then this new labor code came out, and I got to tell you, I'm still confused. A lot of people are still confused. But what it did say is that you have to have rest and recovery periods, and those people have to be paid separately for that. Now, a lot of piece rate companies say, well, we built into the piece rate a rest break, a paid rest break. We knew we're paying this person $300 for 2 hours worth of work, and that's to include that person to have the time to take a break. We built all that in. No, we never wrote it down anywhere, and we never explained it to the employee anywhere, but even a monkey knows that's what we did. It's like, no, that doesn't work. So now, because that happened, and a lot of companies, even if they did have great intentions and they did build it in, they did that in like 1968 and never went back and increased the amounts. And so you couldn't really say that everything had increased along with those rest breaks. So now it says, okay, for rest, you have to have an hourly rate of no less than minimum wage or the employee's average hourly rate for all time worked during the work week. You have to pay them on that. That's how you would come up with the rest break rate. And then there's this non-productive time, which they kind of define but kind of don't, and that's time under the employer's control, exclusive of rest and recovery periods, that's not directly related to the activity for which they're getting compensated on the piece rate basis. So there's the activity that's directly related, which is getting the proper tools and parts into the bay. That would be included for these mechanics. That's part of the project of repairing the transmission. And I guess taking the old motor oil out to the recycling center would be part of installing a whole new transmission. If it's not, don't sit in judgment. I don't know much about cars. But then other things like cleaning, keeping the place clean, tidying things up, updating software, that's not related to the activity, and so that would be not included in the piece rate, and it needs to be compensated. So all these things are describing how it has to be, how you have to, basically the underlying issue is, are people being paid for every minute they are at work? And again, they're not home. And it doesn't just tie to piece rate, it ties to people who are non-exempt, who show up and are having to wait around for you to assign them to do something, or who show up and have to do all this prep work before they get to clock in. Most of which we handle, other cases have already addressed that, but some employers still haven't caught on that if once the person is at work and not doing their own thing at home, then they need to be paid. The other thing, and the big thing about the piece rate AB, so sorry, I'll cut back. So at the top of this page it says AB 1513, piece rate compensation. That means Assembly Bill 1513. And then when it became law, it created this new Labor Code section 226.2. And then if it's a Senate bill, it's called SB something. And that's why some people still refer to the sexual harassment training law as AB 1825, because that was the name of the bill. And then they reuse the bill numbers. So you always kind of want to make sure that sometimes I'll get clients who will send me, oh my gosh, have you seen this new law? And because they'll see that Assembly Bill 15 was passed, and they'll go look at Assembly Bill 15, and it'll be something like, you have to pay people $500 an hour. And it's, well, no, that was an Assembly Bill that was proposed 5 years ago, and they just reused the number, and that Assembly Bill did not pass. So that's what the AB stands for. So the real reason that I find this law important for everybody to look at, so first the concept of paying people for all their time worked, and then the wage statements. The wage statements. Wage statement violations they double, they triple the cost of litigation and damages for pay violations. Because if you, for example, haven't classified somebody as non-exempt and you've paid them as an exempt employee, then their wage statements are all wrong. Okay? They don't have the hours worked. They don't have an hours worked and the amount that the person is paid per hour, and that is just critical. That is a wage statement violation, and the first pay stub the person gets that's wrong is a $50 penalty, and every pay statement thereafter is $100, up to a maximum of $4,000 per employee. So you could sit there and have paid 10 employees wrong for years, and you're looking at, on top of all the other violations, that's 4 times, that's $40,000, right? Is that right? I think that's the number of zeros. I'm doing the new math with my 10-year-old, so having some issues with actual real math. So that's Common Core math to guess like that. So what we have here is wage statements for piece rate employees. It lists what has to be included. So total hours of compensable rest and recovery periods, the rate of compensation, right? That's how much you get paid per hour for rest and recovery periods. All this has to be on the pay stub. And you need to work with your pay provider. If you don't do it in-house, they should be able to do this for you very easily because they knew this law was coming. And it shouldn't cost an astronomical amount because they're having to do it for everyone else who does piece rate compensation. You need to put in the total hours of non-productive time. That must be listed, the rate of compensation for that non-productive time, and then the gross wages paid for that rest and recovery and the non-productive time. So one thing you could do is you could get rid of piece rate and go to the, we're just going to pay you for every hour you worked. That's a way around this problem. And then you could do, in addition to that, money for the actual work performed. So there's a minimum wage for the whole day, plus if you do perform this work, you get paid this extra money. When you do that, you need to be mindful of how that extra money needs to be factored in if there's any overtime. You don't just get to rely upon the minimum rate of $10 an hour and say if you work overtime, we only owe you $15 an hour. You would need to factor in looking back 90 days and doing a calculation to determine what the regular rate is because you would include the piece rate compensation. See? Fascinating. And it's just important to be mindful of that. But it's the wage statements that are important because just as the piece rate compensation wage statements have all these criteria, your normal, I can say anything's normal, your normal wage statements need to be compliant. They need to have all the information. And there's another law that I'm going to talk about in just a second, but this is just a reminder of how important that is. The law includes an affirmative defense or a safe harbor for this, so it allows people, because it was so confusing before this case came about and then the law that they created, they're allowing people to go back and fix it for the period from July 1, 2012 through December 31st, 2015, if they fix it by next December. So it's allowing for the kind of the concept that no one really knew what we were doing, and here we're going to let you, if you pay all the money, you can avoid the penalties and other issues that make these things super expensive. But we want people, we the government, want people to be paid for all their time worked, so you need to fix that. And we're going to give you, this the rare group of people who pay by piece rate get this nice safe harbor to fix things. All the people who have been paying people incorrectly because it's been unclear for years about how to do the exempt status of administrative and executive employees, and the fact that the Labor Commissioner only recently, within the past 10 years, got really hot and heavy about that. No safe harbor for you. But the piece rate compensation, we have a safe harbor. Okay, so that's kind of confusing, but it's important. It's like that section of my, I get the week, and it says boring but important. So this is boring but important. So then another pay stub rule came about and was actually effective earlier in the year. So that's October 2nd, 2015. And the issue is the fact that there's the pay stub rule that says everything you have to include in the pay stub has things in it that people are getting caught on. Employers are getting caught on, and some of them seemed pretty de minimis in terms of importance. And so they're allowing this right to cure. The right to cure will not help you if you're the employer that had misclassified employees and therefore you don't have on the pay stubs the hours worked and the rate. So if you improperly classified people as exempt when they were truly non-exempt, this pay stub cure doesn't really help you. But what it helps you is if you have pay stubs where you either through your own internal payroll or through a payroll service, you didn't have the proper name of the legal employer and address on the pay stub, and you didn't have the inclusive dates of the pay period. Now, I was just at the Labor Commissioner and for a matter, and we had a nice, clean, I thought, defense, except the problem was that the pay stubs were kind of a mess, and the hourly report didn't connect up very cleanly, so it took some explanation, which you don't want with the Labor Commissioner. You want to show the Labor Commissioner like one sheet of paper and have it, here's everything that happened, and here's why the employee knew, and everything was above board. Having said that, both parties to this action created confusion because the employee did not understand the lag between if he worked on January 10th, which, let's say that's a Friday, and he got a paycheck on January 10th, he didn't understand that that paycheck was actually for the previous pay period. He didn't understand that that was for work through the previous Friday. Like that just didn't, he had been thinking about other things. He didn't understand that concept. So it's important to have the labor commissioner understands that some workers don't really focus on that, and so you need to have the inclusive pay period. What does this check cover needs to be on that pay stub. And the name and legal address of the employer is important. Now, we have had cases where the address is missing, okay? And we will have people sue, and those people have driven their car every day to the company's headquarters for 10 years, okay? They know where that employer is, but it's not on the pay stub. That's a technical violation. And before this AB 1506 came into effect, that's $100 per pay stub. And sometimes we're able to negotiate that down because it's like, are you kidding me? But sometimes you're stuck and you're sitting there, and even if you might be able to convince a judge to knock that down, anytime something goes to a judge or a jury, you know, that is just money that is going toward legal defense fees that it's not going to you. That's all I can say. So as of October 2nd, employers have had the right to cure these two technical violations, the pay period and the name and address. So what you need to do is you need to go pull an exempt pay stub and a non-exempt pay stub and make sure it includes everything listed in the code section and that you have it. So in this case, what prompted this is that a company that was Spherian Pacific Workforce LLC, the pay stub said Spherian Pacific Work LLC. So that's a violation of the law. It's not the whole name. It's like, really, $100 per pay stub for that? Yes. So now we have this opportunity to correct. So, but you have to correct. You have to give each employee affected a fully compliant wage statement for each pay period for the 3 years that there is a violation. You can only cure once in a 12-month period. So you don't want to just, you have to be mindful of this, because if you have one employee that complains or you find out a problem and you only correct his, does that prevent you from, so somebody else could come in the door and make the same claim and you've blown your correction. It's kind of like you can't just secretly correct stuff. You have to correct it for everyone. This just affects certain parts of the penalties. The PAGA penalties, the Private Attorney General Act. It doesn't provide protections from the employee's ability to seek penalties under different sections. But having said that, anytime we can reduce penalties, the better. Okay, so this was the longest part of the whole presentation, and now we go, because those are the two big deals, right? I need you to look at how you're paying employees. If you've paid employees and everything's cool and you have the pay stub, then you're going to have less time where you have to talk to people like me. Okay, so going right along, so there had been a case 2 years ago about Orange Coast Memorial Medical. In that case, people who were working an alternative work week schedule, AWS, they had properly voted on it, so they were working in excess of 10-hour days. These guys were actually working 12-hour days because they're in the healthcare industry. They had waived their second meal period. They'd signed a proper waiver that said, I'm waiving my second meal period. I know I can revoke this at any time, and I'm choosing to work through and get out the half an hour early. This Gerard brought a lawsuit, and this court crazily said, oh no, you can't waive the second meal period, even though it's in the law and even though it's in the wage order. I, judge, disagree. So it was kind of like, oh my gosh, what are we going to do? We have all these meal period waivers, and even though it's compliant, it's not compliant. But thankfully, Senate Bill 327 corrected that and said, no, you can have these meal period waivers. So you might not be in the healthcare profession, and you might be like rolling your eyes at me right now. But if you have meal period waivers, you need to go double check them. Do they say that you can revoke this at any time? Does it give the employee the opportunity to revoke the waiver at any time? Because if it doesn't say that, then it's an invalid waiver. So this is just, you need to go check out your waivers, and are they legally compliant? I'm not going to talk this fast, I promise. I'm just going to, I was excited about that one. The labor commissioner, because it was weak and ineffectual before, that's total sarcasm if you can't hear me, has more powers now than ever before. So now if your company is in a place that has a local minimum wage ordinance, San Francisco, Oakland, San Jose, Santa Monica, they have higher minimum wages than the $10 an hour. The labor commissioner used to not be able to enforce that higher minimum wage. So if you said, oh, I'm only getting $10 an hour, your employee said that, the labor commissioner would say, we don't really care. That's compliant. But now they can enforce that. They discovered that it was hard for the employee to go to City Hall and to find somebody who understood the law and who had the power. And so now Labor Commissioner can enforce local minimum wage rules. And the Labor Commissioner, we had fought over this, and we got some Labor Commissioners who would just boot cases, and some would say, well, let's keep them if they were just about expense reimbursement, mileage, cell phones, computers, etc. They would say that's not. Some of them would say it was not in their jurisdiction, and we could get out of those claims at that point, although they could always bring a claim in court. And now the Labor Commissioner specifically has the power to enforce the rules about expense reimbursement. So the Labor Commissioner's powers have increased, and not the problem. Okay, it's a problem if you're in defense, is that it's so easy to file a claim with the Labor Commissioner, and it doesn't require the employee to pay any money. And the Labor Commissioner is designed to help your employees, or the employees of nefarious employers who are not paying people properly, which is not you. But it makes it super easy, and then once you get in there, once the employee gets in there and you're in the conference, the Labor Commissioner does not limit their questions to minimum wage, et cetera. They ask about everything under the sun. And so then you're kind of stuck with, oh my gosh, did we do everything correctly? And that's where it becomes dangerous. The Labor Commissioner has greater powers, and this is just a summary of them, in terms of enforcing judgments that they've issued. And so they can now take liens. They can also seek to find the individually liable for the funds owing to the employees. So that's it's an easier standard than before, when you'd have to prove to prove that you were essentially the company and there is no true corporate existence. Okay, so here's an exciting one. Cheerleaders are employees. You might say, I don't have any cheerleaders. Why did you include this? Okay, so this is a sexy topic because there's the gold rush and the Raiderettes, and they were being treated as independent contractors, even though they were basically having to work 16-hour days and maintain physical fitness and beauty standards, and yet would be paid just very minimal money. So now they're being properly classified as employees. Why this is important is because they were classified as independent contractors. So if you have anyone that you are paying as an independent contractor, this is a nice, more exciting way to remember that you need to take a look at that. Is this person truly an independent contractor? And it doesn't matter what the contractor thinks or wants or is better for them. It matters because that's fine. What matters is what is the relationship really all about. And so it's important to regularly review, especially when you aren't the one in total control of the hiring of contractors, because you'll get, again, it's kind of like the rogue manager is off doing something, and you're like, what is going on here? It is a short-term benefit to pay someone via a 1099 if they should be paid as a non-exempt employee, and especially if they're working 10-hour days on your property, doing things for you, and they're just getting paid as a 1099, and they're doing something that relates to what your business actually produces. That is troublesome, and that's something that the government gets upset about because they're not getting their taxes paid at the time of payment, and the employees are not getting paid properly. So this is a reminder to take a look at your independent contractor relationships and see, are they properly classified? Let's see, it's a much more exciting way to do it than to say, go look at them. Cheerleaders are employees. Okay, the big law that kicked in as of the first of this year is the California Fair Pay Act. And what that is it revises the Fair Pay Acts that have been in existence for decades. The whole point is to try and make it easier to enforce. If you go and look at cases, like you want to see how it's been enforced in the past, it's very difficult to find cases where equal pay is being pursued and enforced. There's two lines that one can use to pursue equal pay. There's the Title VII or discrimination line, and in that under that line of law, if someone's going to file a case under that, they have to prove that the company had a discriminatory intent to make it easier, to pay women less. Okay, and that at times can be a hard standard because how do you prove discrimination unless you have a nice email like "we hate women"? That would make it nice and easy. But then there's the other line of the law, which is the equal pay line, where you don't have to prove discriminatory intent. You just need to show that there was a difference. And under that line of the law, the damages are less. It's less money available to the person who is being mistreated. now we've had, and it was also very difficult to show. These things are difficult to show. So now we have this revision. So the employee must show that he or she was not being paid at the same rate as someone, I'm sorry, wholly just misspoke because I'm looking at the word existing law. So the existing law before this law took effect, sorry about that. I think I need some more coffee. The law before January 1, 2016, the person had like, let's just for the sake of, we'll just be sexist. The woman had to show that she was not being paid at the same rate as a man at the same establishment for equal work. Okay, that seems like, oh, okay, that's a hard standard. Okay, so now we have this change, and it's supposed to create the most aggressive equal pay law in the nation and make it easier to enforce. And it changes that language. And so instead of saying paid the same rate as someone of the opposite sex at the same established for equal work, now it's substantially similar work when viewed as a composite of skill, effort, and responsibility and performed under similar working conditions. So theoretically, under the old law, if you had somebody in Oakland who was being paid less than someone in Berkeley, that would be enough to defeat any claim because that's not the same establishment. But those are like contiguous municipalities, proper terminology. But still, it wouldn't matter. Even though it was the same cost of living, the same rents, the same business expenses, they could say, nope, it's not the same establishment. So that little exception, or huge exception, was taken away. So it's the substantially similar work, which is actually kind of hard to quantify. Someone the other day was talking to me. They run a resort, and they have housekeepers, and then they have the house something else. But it's like it's the same job. It's just only women are called housekeepers, and the men are called something else. And it was just like classic. That's equal pay violation right there, because if people are doing the same work, you've just kind of said something differently. So the new law, like I said, deletes the same establishment, and now you just have to show not the same job, but substantially similar job. Now, sometimes people get upset when I talk about the same establishment requirement being deleted, but that doesn't mean that you have to pay somebody the same. You don't have to pay employees in Reading the same that you would pay them in Palo Alto, right? Because there's cost of living issues that you can take into account. You can also take into account the labor force and the availability of getting people on board. You can pay people differently if they've been based on seniority programs, educational background, if they're able to step in at a higher level of performance. The issue is that the employer has the burden of proof, so you can't just rely upon the fact that you're going to be able to show later that your pay difference was fine. You need to have established that. You need to have the evidence for that ready to go. So let's see. You have to show that if you're going to pay people differently, there has to be a reason other than sex. And so like I said, that's your geographical limitation. There's something that shows you need to have men in this job and you need to pay men more. That there might be a reason for that. It can't be that you only advertise at the local boys' high school, and therefore you only get boys, and therefore you pay them higher. That's just not going to work. What you need to do. Oh, jump to the excitement of what you need to do. But the equal pay, if someone is being paid less, if they win, they'll get the difference in the amount of pay, and they'll get double that as liquidated damages, and then they'll get interest, litigation costs, right, the filing fees, and then the tail that wags the dog, attorney's fees, right, the reason for everybody I know's existence, and then now the labor commissioner can enforce this. So more power for the labor commissioner and ease of pursuit by the plaintiff, because they can just file with the labor commissioner and they don't have to do a formal civil lawsuit. You can't have a contract where you can't have two people with a contract and say, oh, well, this person was a rational business actor and entered into this agreement knowing that she was going to be paid this amount, and so we can rely upon that. And then a man entered into a contract with double that, and he was a rational business actor. That's not going to work. It doesn't matter if there's a contract that sets forth the rates and that the person accepted that as the offer, because the whole point is to get at systemic bias and discrimination that follows people, well, in this case, follows women throughout their employment. Be advised that the goal here is to also tighten the equal pay laws in terms of people of color and people with disabilities. So this is kind of the first round, and we expect to see equal pay to be expanded beyond gender. You can't and you haven't been able to before bar employees from talking about how much they make, and you can't prevent employees from asking others how much they make. Now someone can say, I don't want to tell you, but you can't prohibit the person from asking. So what you need to do is you need to look at your pay. I know that people can help you with this. One quick and easy way is to take a nice spreadsheet and see, who's making what and what they do, and if there's differences of statistical significance. So you're not going to get an Equal Pay Act problem if you're talking pennies, but you want to see if there's statistical significance, and maybe you can just remedy it with a nice bump. Now, the analysis if you do that in-house, it may not be privileged from disclosure, and even if you do it with an attorney, it may not be privileged from disclosure. So you don't want to, the facts are the facts, but you don't need to add on there any comments like, boy, we're going down the gutter. Don't add anything like that onto it because it will all be produced, and then you'll be asked, what did you mean by the gutter? Okay. So you need to review your hiring and compensation practices. If the setting of wages is set by people, if it's not kind of if there's not a central headquarters, for lack of a better phrase, that is reviewing how new employees are being paid, you may want to get that in place so you're not having just random hiring managers on a one-off deciding what wages to pay, because that's not really a defense to say, oh, we had all these disparate individuals deciding how much to pay, and therefore it couldn't possibly have been this conspiracy of equal pay discrimination. That won't work, because the whole point is to show that the people in charge have this innate bias, and therefore each person, when they choose to pay a man, for example, more than a woman, then that's just a perpetuation of that bias. That was a long way of saying, take a look at how you're paying people, and let's check to see if there's any disparities in terms of gender. And to get ahead of the game, you want to, if you can somehow do it in terms of disability and people of color, et cetera, that would also be important. Okay, so now the final little plug here, because I didn't want to chat on too much, but I guess I already have, is the discrimination protections. So nothing too mind-shattering, but important. And these are the ones that sometimes I'll be talking to groups of HR professionals, and they will just say, why is this even a law? And then I'll say, I have actually counseled some companies who wanted to do something like this. So it's important. These are like, again, it may be telling you something you already know, but they had to make it a law because obviously some people were not listening. So the Fair Employment and Housing Act is now amended to say that an employer can't punish, retaliate. And remember, retaliation means termination, demotion, suspension, exclusion, right? Oh, we're not going to invite Jeanine over anymore. What if we say something wrong? That's exclusion. Unreasonable expectations. We're going to retaliate against this person for raising this issue by giving them a job and giving them 2 weeks before we check in to see if they finished it, when really it would take somebody else 4 weeks. And then when they're not able to do it in 2 weeks, we're going to punish them. So retaliation. So employers cannot retaliate against employees who ask for a religious or disability accommodation, regardless of whether the accommodation is granted. So if someone asks for an accommodation for a religion that you don't believe is for real, or if they ask for a disability accommodation and in fact their treating physician says that they don't need that accommodation, they could have this other accommodation, you cannot punish the person for having asked. Okay? And sometimes people do that. Sometimes people, I will get calls, and I will get a call that says, okay, we've gotten a demand letter, which is the letter that comes before a lawsuit is filed sometime. And I always, it makes me think of Austin Powers, because a demand letter usually has like a long list of grievances, and at the very end, Dr. Evil pops up and says, but we will forget all of this if you pay us like $1 billion. So where was I going with that? So I've had demand letters, and then the client has called me and said, I'll ask, well, why did you let this woman go? Because last time it was a woman. And they say to me, oh, well, she was just kind of a whiner and a complainer. Okay, well, what did she complain about? And they say, okay, at the beginning, we didn't have a stand-up desk with 2 computer monitors ready on her first day for her, so she complained about that. And then a couple months later, she complained that we only had Coke and not Pepsi. Then a couple weeks ago, she complained because because she thought she was being sexually harassed, and so we don't need complainer. We gotta terminate. No. You don't terminate somebody for being a complainer. And so this is just to kind of reassert that we don't terminate the person even if in the end they don't have a matter that needs to be accommodated, or that the accommodation, there's a much easier accommodation, a cheaper accommodation. We don't punish people for that. Okay, and that's what I've included that for us. We don't punish people for complaining. We encourage complaints, right? Especially in the sexual harassment scenario, we want people to complain while it's still one stupid joke, so that the person who told the stupid joke can be told to knock it off, and we can all get back to work. Second thing is kind of related to that. So sometimes I'll have situations where the employer knows not to punish the person who complained, but they're still going to make the complaining employee know that they're disappointed by punishing a family member. Okay, so this law just clarifies that you can't punish somebody for the fact that their family member who also works for you complained about how they're getting paid, or that they're harassed, or that they're a whistleblower. You can't say, I'm going to punish Jane because Jim complained about how we're not paying overtime correctly. But I know not to punish Jim because that will be retaliation. So instead I'm going to punish Jane by giving her a bad assignment, or doing, scheduling her for Saturday morning. So basically don't punish people for complaining. You can sum up these two laws. Now I'm zooming. Yeah, I started being a chatty patty. Okay, the last discrimination protection that I wanted to focus on was the limits on EVerify. And I know a lot of you don't use EVerify. You can, but you're not required to. And I do know that a lot of companies now use internet-based first round of employment recruiting. So you have people submit things via the internet, and then through metrics, et cetera, you'll get down to a next round of people that you're going to follow up with. So this rule is that you can't, this is kind of in line with that, you can't can't require or check on somebody through EVerify to see if they're authorized to work in the United States until after you've given them an offer of employment. Unless you're a special federal contractor or something where you have that requirement upon you, you can't use this essentially as a screening technique. You need to offer everyone. If you're going to offer somebody employment, you offer it employment, and then everyone has to produce, that's offered employment must produce their documentation to show that they're authorized to work in the United States. You look at everyone's. It doesn't matter if it's Jane Smith, who looks very Iowa. You're going to look through all of her documentation, just like you're going to look through someone who you think isn't authorized to work. And I got to tell you, oftentimes those stereotypes are flipped right on their head. When I was in law school, they did a raid on the local. I was working at a clinic, and they did a raid on a local car wash, and all the white guys took off when the INS showed up. And all the Latino guys kind of stuck around. They're like, yeah, whatever. And it turns out that the white guys were all here illegally from like Ireland or something. So we don't make presumptions based on how somebody looks. And now, so this is one more way you do not use this is a screening device before the offer of employment. You have to wait until after the offer of employment, and then you use it for all of your prospective employees. Similarly, I learned that sometimes you want to see if you've contracted for somebody to do that initial internet screening for you, you want to see what they're doing. You want to take a look at it. I've had situations where people, the screening was blocking individuals who listed as their email addresses that ended with something like earthlink.com or .net, I think, or AOL.com or Hotmail. And that was a factor that would screen the person out because that meant that they were of a certain age. Okay, which sounds absurd because now maybe it's probably retro even to have that. You're like buying and selling old email addresses. But having said that, the company that I worked with didn't know that that's what the vendor was doing. So take a look. What's going on here? How are they doing this alleged screening, and what are the bases? If you do use EVerify properly, you must tell and the person bounces back as not having the right Social Security number, et cetera. You must tell the person that that's what happened so that they have the chance to either correct it or to point out that there was a problem or to find out what's going on. because it may be that it's not their fault and they are, in fact, authorized to work in the United States. Okay, and then my last slide is about things that didn't happen. And, I used to be, and I know people, and this is not to say that it's not interesting. It's not my cup of tea anymore because I have more exciting things, like I have to hone up on the infield fly rule for my umpiring. But, tracking legislation, okay, because now we've entered the time of year when legislation is getting proposed, and then it's going to start filtering through the California legislature, and there's certain deadlines that's going to happen, and now's the time to get ready to go talk to your legislatures, et cetera. So I used to track that, and it's still very important, especially if there's issues that are of significance to you. But as a lawyer, most of the things that are of significance to me aren't of significance until they actually become law. So I usually don't now pay too much attention until it's no longer an AB, but actually no longer an assembly bill, but actually something signed by the governor in October. But having said that, it was important to see that the important thing to note is that legislators are just like us. And so they're not just going to be like, oh, I proposed this and it didn't work, and so it must never work. I'm never going to propose it again. They're going to keep those same bills sitting in their binder, and the next year they're going to propose it. They might tweak it a little bit, or they might know that the population of the legislature has changed, and so things will keep coming up, especially laws that do not require the government to spend any money, right? That's why the change in January 2015 that requires your sexual harassment trainers to talk about abusive conduct in the workplace, right? That didn't cost the government anything. Paid sick leave kind of doesn't cost the government nearly as much as it costs the employer. So all these things, they're put up, they're rejected, they're put up again, they're rejected, and then they become law. Okay, so here it's important. I picked these three things because I think it's important. So I didn't correct that typo. I apologize. It's not, so working from the bottom, it's not ASB. Is it? It might be. Maybe it's Assembly Senate bill. But I think it's just Assembly Bill 406 that would expand the California Family Rights Act. And that's going to expand who somebody can take time off to care for. And that's just one more thing that someone can take time off, unpaid time, and then come back to work protected. So that is a change that's likely coming. So you'll want to keep an eye out because you always want to be making sure that you're not blocking people's entitlement to time off and assuming that because you are epically awesome about leaves of absence, you know everything when in fact this change could come up. And the second, I'm sure HR Options will have an awesome seminar on it, but just kind of giving you the heads up. And then AB 676, this is the one that I actually don't think will ever come up, but it's put up every year, and it's interesting, that prohibits an employer from discriminating against people who don't have jobs at the time they apply. This is a big deal in like 2008, 2007 during the recession, where people were saying we're not going to hire people who don't have jobs. And then lastly, the most important thing, AB 465 was going to ban arbitration agreements in employment. That didn't pass. If you don't have arbitration agreements with your employees, I strongly recommend that you talk to HR Options, you talk with your counsel, because just in terms of, like I said back when I said that the one law doesn't eliminate all the penalties, but it helps get rid of one type of penalty, anything you can do in the wage and hour context that can reduce the penalties, the better. And so you want to take a close look at this to see if you can get arbitration agreements up so that you're only having to deal, for the most part, with one employee's claims as opposed to one employee on behalf of all 250 of your employees. And that's it. Everything you needed to know, talking way too fast.
Wonderful.
I apologize.
No,
Sorry.
thank you, Jeanine. No, thank you for bringing us up to speed on these changes. I know it could be a lot longer session, so we appreciate you trying to jam everything into this short period of time. We have a couple questions. I want to jump right into it. And the first question is, can family members of the owner be classified as exempt, even if they don't qualify under any of the exemption tests?
Sometimes, yes. There are specific rules in the wage order, which I am loath to pull up right now. But yes, certain family members you can pay differently. But you have to go look at it specifically. And it has to be, this isn't like, Jim, second cousin removed. So there's rules about how you can pay your own kids and your wife. Or oh my gosh, that was so sexist. Or your husband if you let him come work for you. Sorry. But you need to look at the specific question.
Okay, great. There's a question about PEOs like Trinet. And so apparently there's a company called Les Concierges and the pay stub and the W-2 stated that TriNet was the employer for the workers, but Les Concierges was found as the employer, even though they were the client. Would this mean that the employer listed on the W-2 and pay stub was incorrect? Because the job offers, I guess in this case, came from Les Concierges and not TriNet, but the pay stubs obviously stated TriNet. So can you speak to this co-employment situation with PEOs?
Well, if you'd like to, Amy. I'll
put my 2 cents.
Okay.
Yes.
So really fast, the whole point is, can the employee find the person to sue? And so you can't have, that's the whole problem with the, because we'll fight. If you sue me under the name J.D. DeBacker, I'll say that's not me, I'm Jeanine DeBacker, and now you have to fix that. So does the employee have the sufficient information to sue? In the co-employment situation, the legal employer was probably TriNet. That's why there's that double, the Wage Theft Protection Act notice, which employees get upon hire, that says, here's the legal name and address if you're going to sue. But then you're right, there's also that co-employment. So I don't know off the top of my head. Amy, you know, let me know.
So because HR Options, as an outsourced employer, there's co-employment liability with the workers that we hire. But what's important for you all to know is, or to understand, is that a PEO is a specific type of organization, and they go into contractual agreements with their clients to have joint co-employment liability. And it's drafted in the agreement that you're going to share the liability as the employer. When you call Kelly Services or HR Options, we're a human resource organization, and both staffing firms and HR Options, we look to protect the clients from co-employment liability by putting ourselves as the primary employer and doing everything from, making sure our clients understand we're the ones who make the job offer, we're the only ones who have the right to terminate, and taking on those full roles. It's a different situation than the PEOs. It's not to say that there's no co-employment liability. There is, but they're definitely different animals, and when you're working with a PEO, you're not protecting yourself from co-employment liability. So just be aware of that. If anyone wants to talk to me more about that, I'm happy to do that offline. But let's move on to our next question is our IT manager exempt under the computer software exemptions?
And no, unless your IT manager has subordinates, 2 or more that person actually manages, and has the authority to hire and fire, et cetera, and meets the managerial or executive exemption, they wouldn't be exempt simply because their title is IT manager and simply because they're involved with computers. The computer software exemption has very detailed exempt status rules you have to follow. And so if that is not satisfied, if they're just there to make sure that your server's working correctly and that you're able to do things, which is very important. I didn't mean to say it like that, because the whole thing could be crippled without the IT manager being able to be effective. But that's not what the computer software exemption is for. So unless they actually are managing people, they would likely not be properly classified as exempt.
Okay. So one of the questions is if area differentials qualify as a justification for pay differences on the Fair Pay Act. So geographically different areas, does that qualify?
Yes, it can, but it has to be real. So like I said, it can't be Berkeley and Oakland. It has to be like San Diego. If looking for a certain type of employee, it might be harder to get that employee, and the cost of living is higher there than
Lodi.
Sacramento. Mm-hmm. Yeah, Lodi, where I'm from. Yeah, so yeah.
All right,
you can
perfect.
pay people differently.
What if a man works for us longer than a woman, but it's the same job? Must we pay them the same?
No. So you can have seniority, and it doesn't have to be a formal like collective bargaining agreement seniority plan. And I've gotten a lot of questions about this. If someone works for you longer, then they can be further along the pay road. You would want the woman to be moving at the same rate in terms of increases. You don't want to artificially suppress wages. So that's something to consider. But keeping in mind, and as well, the whole idea that it's just like anything else. The whole point is we're trying to get at systemic historical issues here. So if You can't say I'm going to pay this guy $100,000 and I'm going to pay her $50,000 and then increase her by $100 every year. Then it's never going to catch up. And so you can't artificially suppress wages, but you can pay people differently based on how long they've worked for your company.
Great. Well, that is all that we have time for today. I wanted to thank you again, Jeanine, for your time and sharing your expertise.
Thank you. And have a wonderful day.
I also want to thank everyone else for joining us today. If before you leave, you could hit the red button at the bottom of your screen for our evaluation. We would love to have your feedback, and we look forward to seeing you at future webinars. Have a great day, everyone.